All right, discuss and describe the types of evidence the plaintiffs would need to offer at trial to meet their burden of proof. So first, we would start with the standard of care, which is the caution and prudence that a reasonable person would exercise under the circumstances or that are required by appropriate authority for such situations. So, in this specific case, the anesthesiologist was supposed to give anesthesia and to be aware of when a patient is awake or asleep. Another thing to mention is the breach of duty, which is once the duty has been established, the plaintiff must show that the defendant breached that duty by presenting evidence of the facts of the case and testimony from expert witnesses regarding whether or not that the standard was met. Now, if I correctly remember, the anesthesiologist team had one job, was to give anesthesia to the patient, but forgot to turn the gas on. Then realized that the patient was awake the entire time. They were 16 minutes into the surgery, and they still didn't tell the patient what happened. So I think with this, they have a specific amount of steps that they're supposed to take that they have to follow, like put a mask on, then turn on the gas, and then give them the non-polarized drug. So obviously they put the mask on, but they forgot to turn the anesthesia on for the gas for the anesthesia, and then they went and gave him the non-polarized drug anyways. Discuss and describe the types of defenses that these anesthesia associates could raise in response to plaintiff's pleading. Some of the defense were if malpractice defendants may have legal defenses that can clear or reduce their liability, even if a plaintiff can prove all the elements of the case. So at this point, this is when the apology law would come in, and medical error would come in, which apology law essentially gives the doctors the choice to make an ethically good decision on whether or not to disclose what actually happened. Another thing, which is contributory and comparative negligence, which is common law doctrines relating to allocation of responsibility when the plaintiff was partially at fault, or where comparative negligence is an attempt to compensate the injured party in some way despite the injured party's own negligence. There's the assumption of risk, which is an affirmative defense that a defendant can rise in a negligent action. So they have the apology law here, so they technically could make the ethical decision to apologize, essentially, and to make sure that they either can disclose all of the information that they want to, or they could not disclose all the information, which at this point they didn't disclose all of the information clearly, but which then led to an injury because of the fact that they forgot to give him anesthesia. Describe and discuss the types of damages the plaintiff would be entitled to if they prevailed at trial. There's the proximate care, which is the legal cause of the damages to the plaintiff, the cause that immediately precedes and produces effect. Another thing is that the purpose of malpractice trial is not to convict the defendant, but to decide whether the plaintiff's loss is more likely than not the result of substandard conduct on the part of the defendant. The court may determine that only some of the patient's injuries resulted in negligence. Another thing is punitive damages are seldom awarded in negligence cases. The most common damages are actually called actual or compensatory damages.